Good morning. I think it's 1100 hours and about 30 seconds, and therefore it's time to kick off. Welcome to the Cornerstone webinar on the freshly minted Bill of Rights Bill, or depending on your perspective, Human Rights Light, that difficult second album. I'm joined virtually and in some cases actually by Estelle Dehon QC, Andy Lane, Dr. Christina Lienen, and Verity Bell. And in this hour, we will explain what the bill seeks to do and consider its likely impact on domestic human rights law. Now, these are early days for this infant bill. It's just toddled into Parliament for its first reading and is now having a well-earned nap over the summer recess. And it will have some difficult days ahead. In particular, I foresee its teenage years in the House of Lords will be fraught with difficulty. But when it finally comes of age, and I assume it will do, Cornerstone will host a series of specific webinars looking at our individual areas of practice and considering what the changes, what impact they will have on those areas. But for this morning, I will provide a short overview and a summary of the bill's main provisions. Christina will then talk about the repeal of the Section 3 interpretive obligation and common law constitutional rights. And if you'd like to know more about the former, you have come to the right place, because Christina's book, The Nuanced Constitution, A Critique of Common Law Constitutional Rights, will be published early next year, available in every good bookshop or Amazon. Cheaper, but not quite as worthy, your choice. Verity will then explain what's happening to positive obligations under the bill before Estelle sets out the bill's position on remedies and also looks ahead at its potential impact on environmental law. And then Andy Lane will, as he so often does, jog in slowly at the back, and he will talk about the effects on housing law, so providing a foretaste of the approach we will take in the months to come. Finally, depending on time, we'll answer some of the questions that were submitted in advance, although we've tried to answer some of them in our presentations. And finally, this being a webinar, you don't need to know where our fire exits are, but rest assured we have some. So, to misquote the great David Byrne, how did we get here? Well, it was in 1997 when the new Labour government declared that the time had come to bring rights home when publishing the Human Rights Bill. And the Act, providing for the domestic incorporation of the Convention of Rights, did indeed bring rights home in ways with which we are all familiar. It also had a little known unintended consequence. It devastated the Strasbourg tourism industry, as government lawyers could stay at home and get a kicking in the High Court rather than going to Strasbourg for that purpose. But as we know, the operation of the Act has been in the sights of the Conservative government for quite some time. And that came to a head in its last election manifesto, when it stated, we will update the Human Rights Act and administrative law to ensure that there's a proper balance between the rights of individuals, our vital national security, and effective government. Now, there was no talk then about how the Act was to be updated. There was no suggestion of replacing it, and the question of what that proper balance was left unsaid. Spin forward to June of this year, and we now see what is intended. And as you all now doubtless know, the bill seeks to repeal the 1998 Act. And in fact, it says that in more than one place, just in case we had any doubt at all. And in fact, if you read it, you will see that clause 1 reads more like a mission statement than a section of an act. Now, the government's view of the bill is clear from the explanatory notes. It considers it will restore a common sense approach to human rights in the UK context. It will protect people's fundamental rights while safeguarding the broader public interest, respecting the will of elected representatives in Parliament. And it is absolutely clear that what is intended is a complete revision of the domestic framework for protecting convention rights. And it's also clear to me that as and when the bill is enacted, it will generate a huge amount of litigation as the courts seek to understand quite what is intended and how much of the existing law remains good law or is to be discarded. So if the hope is less scrutiny and less litigation, I suspect those hopes will be dashed, at least in the short term. So what will stay the same? Well, I highlight on this slide some 5 points of seeming similarity. The first is that the UK will remain a state party to the ECHR. Although I do put a caveat down because I noted that during the current leadership election, Suella Braverman spoke about leaving the convention, and if she's appointed or reappointed as Attorney General, we may have to think again. But for the moment, it's a key premise upon which the bill is drafted, and it means that the UK will remain bound in international law by its treaty obligations under the convention. And these include Article 46, which requires states to abide by the final judgment of the European Court of Human Rights in any case to which they are parties. So that will remain an ultimate safeguard, albeit a very remote one for the vast majority of litigants in the courts of England and Wales. Secondly, the bill does give effect to the same convention rights as does the Act. So still Articles 2 to 12 of the Convention, Articles 1 to 3 of the first protocol, and Article 1 of the 13th protocol. It's good to see the abolition of the death penalty getting mentioned there just in case. Therefore, there is no change to the scope of the range of rights that will be given domestic effect. The third seeming similarity is the courts will remain empowered to make declarations of incompatibility. This mirrors the current Section 4, and as with Section 4, the making of declarations will not invalidate the legislation itself. Fourthly, it will remain unlawful for public authorities to act in a way which is incompatible with convention rights, Clause 12 mirroring Section 6.1. And finally, it will remain open to those who consider they are victims of an act or intended act to bring proceedings before the court. So those are the similarities. However, they are, in my view, superficial similarities because the bill is designed to dilute domestic rights protection. So in particular, although there is the possibility of legislation being found to be incompatible, that sits within a significantly different framework to the existing one. And as we'll see, it's a far lighter touch, placing far greater emphasis on parliamentary sovereignty and conventional rules of construction. Secondly, the bill seeks to limit the ability of the courts to read convention rights generously in an always speaking fashion. And thirdly, because of these two earlier points, although authorities still can't act incompatibly with the rights, the duties on public authorities will likely be less onerous. It does seem to me that this will in due course be felt by local authority clients. And the final point, although one can bring proceedings for breaches of the Act, there is a permission stage of a significant disadvantage, which, as it seems to me, is intended to be a high threshold. The next slide, please. So over the next two slides, before I sit down or just stop talking, I've highlighted what I think are the 5 major changes in the legislation. And I'll summarize these briefly before the others get more to the meat of them, or the meat substitute, if you prefer. Now, the first of these is an absence of an equivalent provision such as Section 3, the Interpretive Provision. And the courts will no longer be required to read and give effect to legislation as far as possible in a way which is compatible with convention rights. That's clause 1(2)(b). And indeed, the courts are newly directed as to the restricted approach to be taken when considering an incompatibility question, including as the approach to proportionality. Now, Christina will explain in greater detail the repeal of Section 3 and what is intended to come in its stead. But it does seem to me it will strike a death knell to decisions such as the House of Lords decision of Gaydan and Godin Mendoza, where the committee there relied upon Section 3 and Articles 8 and 14 to read the Rent Act as permitting a same-sex partner to succeed to the tenancy of their deceased partner. That wouldn't have been possible without Section 3, and given the slant of the bill, I doubt it will be possible in the future. The second main change is the absence of an equivalent provision to Section 2, i.e. the one that's concerned with interpretation of convention rights. For example, the courts will no longer be required to take into account European Court of Human Rights decisions. Indeed, there is a steer that the courts should focus on the wording of the rights and may indeed focus on the travaux préparatoires, which to me at least brings shades of the current majority approach to the US Constitution in the Supreme Court. And there is then a statement affirming that the Supreme Court is the ultimate judicial authority on questions arising under domestic law in connection with convention rights, before we have two further steers in clause 3. Firstly, that a court may not adopt an interpretation of a right that expands the protection conferred by the right unless it has no reasonable doubt that the European Court would adopt that interpretation if the case was before it. But secondly, it goes on to permit the court to adopt an interpretation that diverges from ECHR decisions. So the clear intention here, it seems to me, is to permit the courts to hold, and certainly respondent public authorities to argue, for more restricted interpretations of convention rights than has hitherto been the case, or indeed would be the case if the matter was heard in Strasbourg. The next slide, please, Andy. Thank you. And then the final 3 points here. It works really well, doesn't it? Andy doing all of our slides. 3 more major changes. The third one is positive obligations. And Verity will explain the likely effect of this change, but essentially the court will not be permitted to adopt a post-commencement interpretation of a convention right that would require an authority to act to comply with a positive obligation. And furthermore, the courts are signposted to seek to limit the application of any pre-commencement interpretations which give rise to such obligations. Again, in other words, the UK courts will be prohibited from interpreting convention rights in ways which will compel public authorities to undertake positive action. And this is so even if that is what happened in the court, the European Court itself. So a clear case of divergence. Moving on then to public authorities, the clause 12.2 defence is broadly the same as that under section 6.2 of the 1998 Act, but the effect of repealing section 3 and the narrowing of the interpretation of the convention rights that the Act permits will inevitably broaden the ambit of that defence. So a local authority, for example, will, I think, have less onerous responsibilities. But for my own part, I don't think that should really be overstated, at least not at this stage, because firstly, that won't stop the points being litigated and costs being incurred. And secondly, in some areas, I'm thinking in particular of housing law, the big human rights points, as Andy will explain later, have already been litigated. And often the main challenges that local housing authorities face to their decision-making, their policies, is not the Human Rights Act, but the rather more focused Equality Act, and those challenges will remain. And then the final main point is declarations of incompatibility. And it follows from the different approach to interpretation of statutes under the bill that there is a greater prospect of declarations of incompatibility being made rather than convention compliant readings being sought after. And what the bill doesn't say, it doesn't give any steer as to whether or when remedial action will follow. The government very obviously wishes to place itself firmly back in the driving seat. And Estelle will talk about remedies generally. So these then are the main provisions. There are many others, particularly in areas such as deportation and military operations overseas, where the proposed changes will have a significant impact. But these are not for today. Christina, I hand the imaginary microphone to you.
Thank you, Ranjit, and good morning from me as well. So I'll be talking about the expected repeal of Section 3 of the Human Rights Act and common law constitutional rights and the link between the two. And I thought a helpful introduction to this topic would be some quotes from which are taken from the Human Rights Act reform government's consultation response. So the preceding consultation into the government's proposal to replace the Human Rights Act was launched in December of last year, and that followed the publication of the final report by the Independent Human Rights Act Review, which had been commissioned by the government and which incidentally had concluded that overall the Human Rights Act was working well. The consultation closed in March this year, and just under 13,000 responses to the consultation were received by academics, by legal professionals, by members of the public, NGOs, and others. What we can see from these quotes is that there is a clear message that A, the constitutional rights vested in the common law ought to be strengthened, according to the government's view, and B, that Section 3 has been used illegitimately or has somehow had an inappropriate effect on human rights litigation, therefore warranting it to be repealed. So I've just put a few quotes there to introduce the government's thinking on these things, and I will discuss both topics now. Starting with the next slide. Thank you, Andy. So what is the link between Section 3 and common law constitutional rights? Put very shortly, both are effectively mechanisms which shape, contextualize, and in certain instances, qualify majority will by reading primary and secondary legislation in a way that affords respect to human rights. In the context of convention rights, the courts are required currently by the Human Rights Act, by Section 3, to interpret legislation, and this is the famous mechanism or the famous test or instruction to the courts, so far as it is possible to do so, compatibly with the rights protected under the Convention. And this duty applies to all courts and tribunals in this jurisdiction. Now, why is this wording significant or remarkable, one might ask? Personally, I'm not sure that it is. It merely does what the Human Rights Act set out to do, namely to protect human rights and to avoid falling short of the protections under the European Convention, which the government, after all, signed up to. Section 3 interpretation is the closest this jurisdiction has to constitutional review, which is very common in many other both civil and common law jurisdictions, but which we don't have. And Section 3, importantly, does not go as far as constitutional review. If statutory wording is clear, the courts cannot, if primary statutory wording is clear, that is, the courts cannot interfere with it, as was shown, for example, in the 2014 Supreme Court judgment in Nicholson and Ministry of Justice, which was highlighted by one of our participants who had sent in a question about that. The section's critics say, nonetheless, in spite of what I just said, that it undermines, Section 3 undermines parliamentary sovereignty because of the degree to which statutory wording can be interpreted away, one might say, from the actual objective or literal wording or meaning of the statute. And cases such as the one mentioned by Ranjit just now, but also, for example, R&A number 2, another House of Lords decision, are viewed with criticism by skeptics of Section 3. Moving on then to common law constitutional rights. So these are effectively human rights that are conceptualized as something that is inherent in domestic law, specifically the common law. So they are judge-made rights that have been developed in some cases over centuries, and they are typically conceptualized as a counterpart and as being equal to the protection offered by the European Convention. As I highlight on the next slide, they are not as homogeneous a concept or a legal tool as the label might suggest. What I want to stress here is that, importantly, there is perhaps a bit of a logical flaw in the government's emphasis and indeed insistence on common law constitutional rights, because they are enforced similarly to the interpretative mechanism under Section 3, very often by the principle of legality. In fact, it was a common law constitutional rights case, Unison and Lord Chancellor, which paved the way for the very expansive constitutional landmark decision and for the judicial reasoning in Miller and Prime Minister. And it's therefore, in my view, interesting that the government advocates a turn to common law constitutional rights as the solution to a perceived decline in parliamentary sovereignty, or which actually seems to be the concern of the government, limits on executive law and decision-making. I will deal with the last question on this slide, was what does the Bill of Rights bill say about common law constitutional rights, on my last slide. So if I could just, thank you. So what I've highlighted here in relation to the repeal of Section 3 is part of the explanatory notes accompanying the bill, which explains that the repeal of Section 3 will restore a proper constitutional balance by the courts interpreting legislation under orthodox principles of construction. However, again, one might ask here, what does that actually mean? The case of Enes Minnick, for example, was decided well before the Human Rights Act was even on the horizon. And what about more recent landmark constitutional cases, for example, Privacy International and Investigatory Powers Tribunal? These cases, without referring to Section 3, adopt a very rule of law centric type of constitutional reasoning that doesn't rely on the convention really at all. And what I would say here is that there is in fact no generally established or applied approach to interpreting legislation where convention rights or common law constitutional rights are at stake. And in any case, outside of Section 3, the rule of law component of the Constitution is able to lead to highly interpretative readings of primary legislation. Two final points I will highlight here is that the repeal of Section 3 risks that the UK yet again falls behind the Strasbourg case law in a way that will prompt more individuals unable to enforce their rights domestically under the convention at home to make applications or to have to make applications to the European Court of Human Rights in Strasbourg instead. Also, a topic that Estelle will expand on in her presentation, Section 3 has effectively limited the need for declarations of incompatibility, which have been conceptualized and utilized as a measure of last resort in public law adjudication to do with human rights. And there's a real likelihood that we will, if the bill passes in its current form and wording, see an increase in these declarations, which do not, importantly, assist the litigants arguing the actual case. Moving on to my last slide then, please. A few things that I wanted to stress about common law constitutional rights. We might see, given the government's insistence on common law constitutional rights being resorted to more frequently in public law human rights litigation, an analogy or a repetition of what happened in the 1980s and 1990s. So some of you may remember that this is the era in which common law constitutional rights initially flourished or were perhaps shaped into a theme or a concept. And that was in large part due to there not being sufficient protection of convention rights at home, because the Human Rights Act only entered into force in October of 2002. So that the courts were effectively trying to guarantee a similar level of protection under domestic law, and the common law seemed to be the most appropriate tool to do that. If we look at common law constitutional rights today, so about 30, 40 years after they initially rose to fame in the 1980s and 1990s, we can see that, yes, they are a concept, they share certain similarities. However, they are not a homogeneous mass by any means. They vary greatly in terms of how well they are established, how many situations they apply to, the scope, the different legal tests that are employed to enforce them. And so it is very difficult to actually come up with a list or a charter of common law constitutional rights. That is not to say that some have not tried. So the Smith's Judicial Review, for example, has a list or is attempting to create a list of the rights that we currently have. However, if one looks at those rights more closely, one can actually see that a lot of the rights that are mentioned in a sort of generic form do actually, on closer scrutiny, not really provide individual litigants with what one might think. So a very good example of this is the right to freedom from torture, which one would hope is protected domestically and which is listed. But in fact, we don't have a domestic right to freedom from torture. What we do have currently is a right that evidence that was obtained by torture is not admissible in courts in the UK. So the right might suggest that there is that freedom or there is that right, but actually we don't have a general right of freedom from torture. And academics across the board, there's a very good book, if you're interested in this topic, which is just entitled Common Law Constitutional Rights, also by Bloomsbury Publishing, where many academics came together to look at this concept through different chapters on individual rights. And the general consensus is that common law constitutional rights do not offer anything near the same level of protection as the European Convention on Human Rights does. And I would agree with that. One example, and this is something that the government is stressing in various communications, is that they say the right to free speech, for example, is a quintessentially British right, which ought to be strengthened. However, the jurisprudential history of this country does not actually support or uphold that contention. It is not the kind of right where one would turn to the common law as one would, for example, for process rights, so access to justice, for example. Free speech is very much largely a convention right rather than a common law right. And there are various references to famous cases that reportedly protected common law constitutional rights, including Somerset and Stewart, where actually the rhetoric is somewhat stronger and the romanticization of these types of famous cases does not actually match the jurisprudential reality. Concluding my part then, I would finally say that just to highlight what I've said before, the interpretative mechanisms after the judgment in Sims, as can be seen in Unison, are actually sometimes very similar, if not identical, to the ECHR. After the judgment in Kennedy and Information Commissioner, we know as well that common law constitutional rights are enforced by way of the proportionality review test. So again, very similar to the rights under the convention. And as we've already heard, positive obligations are no more to be a thing from a certain point in time going forward. However, common law constitutional rights, in fact, protect positive obligations, as the judgment in Osborne and Parole Board, for example, highlights. Very finally, what the government is suggesting, where they're effectively saying that a court has the right or is able to or may, I think as it is put, consider common law constitutional rights rather than just looking at convention rights. The Supreme Court's jurisprudence of the past 10 years has already established that, and in fact goes much further than that by saying that we should first turn to the common law for rights protection anyways, and they're slightly more prescriptive in their call to do that. So whether there's really anything new that is being suggested by these proposals, or whether this feeds into the narrative of having a more domestic or national human rights protection, that's a question that certainly can be asked. Thank you very much.
Thank you, Christina. You'll have heard today from Ranjit and Christina how various ways the Bill of Rights Bill seeks to control or curtail the approach of courts in the UK when they apply and interpret convention rights in various ways. And today I'm just going to focus on one particular aspect of this restriction, namely the scope of the court's interpretation permitted in relation to positive obligations under Clause 5 of the bill. I wanted to start by going back to basics on this and ask, well, what do we mean by a positive obligation in the context of interpreting a convention right? And Clause 5.7 of the bill contains arguably the broadest possible definition of that, simply an obligation on a public authority to do any act. And I think while there's a lot of academic and theoretical debate about the difference between a positive and a negative obligation in practice, one good illustration of the conceptual difference between those two ideas is in the context of Article 2.1. So that provides that the right to life shall be protected by law. This entails both a negative obligation on the state to refrain from taking life, but also a positive obligation to take appropriate measures to safeguard life in certain contexts, such as taking steps to protect someone from a known risk to life and to ensure the effective investigation of the facts of a death through, for example, an inquest process. Just to give you a bit of an overview, the European Court of Human Rights in Strasbourg has interpreted various convention rights as conferring a positive obligation on the state to do something. In Osman and UK, that's a particularly famous case, the court established a well-known two-stage test for determining when a public body such as the police has breached an operational duty pursuant to Article 2 to protect an individual where that individual's life is at risk from the criminal acts of another. First, it must be established that the authority knew or ought to have known at the time of a real and immediate risk to the life of an identified individual from the criminal acts of a third party. And second, that they failed to do all they could have reasonably been expected to do in order to avoid that risk. For those of you working in the housing and social care context, perhaps a more relevant example of examples where the Strasbourg court have interpreted a convention right so as to confer a positive obligation is the 2009 decision there in Zehetner in Austria, where the court recognised that in order to respect an applicant's right pursuant to Article 8, so their right to private life, where the applicant lacked the mental capacity to participate in possession proceedings, there was a positive duty on the state to make specific legal provision to ensure that individual could do so. So, for example, that might be through the having a system to appoint a litigation friend. So it's certainly not just in the context of Article 2 that convention rights are interpreted as requiring the state to do something and not merely refrain from doing something. And I wanted to highlight that that can cut across arguably all convention rights. The other reason I wanted to set out Osman there and other related cases is to really provide background for the political context sitting behind some of the far-reaching changes introduced by Clause 5, which I'll get to on my next slide. The government's command paper prior to the consultation on the HRA law this year stated at paragraph 150, the expansion of human rights law by courts imposing overly prescriptive positive obligations on police forces and other frontline public services across the UK risks skewing operational priorities and requiring public services to allocate scarce resources to contest and mitigate legal liability. We take a principled view that decisions on the allocation of resources should be determined by elected lawmakers. So you might query the extent to which the electorate or an individual can meaningfully participate in a decision or a police operational decision, for example. But in any event, it's clear that the bill is designed to stop courts applying interpretations of convention rights which require public bodies to act in a particular way, to tell a public body how they ought to allocate resources or funds in particular. Could I have the next slide, please, Andy? So how does Clause 5 of the bill seek to achieve this while the UK remains a party to the convention and required to abide by the rulings of the court in Strasbourg? The clause creates a fundamental distinction between the interpretation of convention rights prior to the commencement date of implementing the Act, so the Act that implements the bill, and the interpretation after that date. And the more observant amongst you will have noticed a pink dinosaur on this slide. And that's because, in my view, Clause 5.1 in effect fossilizes permissible interpretations of convention rights in time. It's like they're frozen or preserved. And that point in time is the date of commencement, after which a court is prevented from adopting a post-commencement interpretation of a convention right that would require a public body or public authority to comply with a positive obligation. And there is no exception to this rule for the what I'd say is an obvious risk that some subsequent decision of the Strasbourg Court interprets a convention right in a new way so as to impose a positive obligation on a public body. In effect, this clause mandates a divergence between the domestic court and Strasbourg, while the Strasbourg jurisprudence can continue to evolve or change as a living instrument. The courts at home domestically are stuck with a fossilized version upon the date of commencement. What about existing positive obligations prior to commencement? Well, Clause 5.2 of the bill seeks to constrain the court's application of these, requiring the court to give great weight to a series of factors. I've set those out in the pink boxes there. These include the obligation to avoid or to place great weight on the requirement to avoiding an interpretation of a convention right that would impact any public authority from performing its functions. A further example, I think, reflects perhaps the court's concern with Osman is at 5.2c, which is to require that the placing great weight on the avoiding interpreting a positive obligation that would require the police to protect individuals who are involved in criminal activity or otherwise undermine the police's ability to determine their operational priorities. It is difficult to see how far these factors will actually take courts in practice and how they will approach the effect of giving great weight, where the consequence of that would be to diverge with a long-established positive obligation. In my view, if Clause 5 is enacted in its current law form and judges apply it at face value, there are likely to be successful Strasbourg challenges whenever a positive obligation is engaged, whether or not that's pre or post commencement. And also domestically, far greater debate about whether conceptually a given obligation on the state in practice is positive or negative in order to try and get round the far-reaching effect of Clause 5. I'll hand over to Estelle next.
Thank you very much indeed, Verity, and for the most effective deployment of a fossil-based analogy that I have yet come across. So it turns to me to cover remedies, and I'll cover two aspects of that. First, declarations of incompatibility. And you'll have heard from a number of speakers already that the changes to Section 3 mean that the practice of retaining convention rights as justiciable in the UK is kind of coming at the cost of more declarations of incompatibility. They will become more prevalent as the main remedy. The three clauses that are relevant here are clauses 10, 25 and 26. And clause 10 makes it clear that the court is allowed to make a declaration of incompatibility where there is an incompatibility with convention rights in any proceedings where the court is satisfied that the primary legislation is incompatible or that subordinate legislation is incompatible and the court decides not to quash that legislation. Two things to point out there. First, the court may make a declaration, so there is that flexibility. And second, it's a bit of an odd change, the position in relation to secondary legislation. So the remedy is usually quashing, and under Section 4 as it currently sits in the Human Rights Act, a declaration of incompatibility for secondary legislation is only available where, because of the primary legislation, a quashing order wouldn't do the job of removing the incompatibility. There's no real explanation for the change of greater flexibility in relation to declarations of incompatibility for secondary legislation, just as it is recognised as change. So what happens when there is a declaration of incompatibility? Well, we look at clauses 25 and 26 in order to understand what the upshot is. Clause 25 requires Parliament to be notified of a failure to comply with the Convention rights. That applies both where there's a declaration made by the UK courts and indeed where there's a finding by the Strasbourg court of a failure to comply with the Convention. But all that must happen is that the Secretary of State must lay before Parliament notice of the judgment or declaration. Clause 26 then gives the Secretary of State power to take remedial action, but only, quote, if a minister of the Crown considers that there are compelling reasons for proceeding under this section, and they may make regulations which amend legislation and in a way that they consider necessary to remove the incompatibility. I note that this also applies where there's been a quashing order, so it applies across the board where there's some sort of incompatibility or lack of compliance with human rights. So there's a clear message, in my view, in clauses 25 and 26, which is that the executive may or may not comply with adverse rulings of the Court of Human Rights, or may not respond to declarations of incompatibility. And that depends not on what Parliament's view is, although the obligation to inform Parliament may allow Parliament to have a debate on that matter. And of course, if there's some amendment to primary legislation, there'll be a debate. But primarily, the bill envisages that the executive will be responsible for determining the response to a lack of compliance with human rights. And that is only where there's quote unquote compelling reasons, whatever that might mean, presumably because a decision that the United Kingdom is in breach of its human rights obligations is insufficiently compelling in and of itself. Ranjit, though, of course, mentioned that the UK remains committed to Article 46 of the European Convention on Human Rights to give effect to judgments, so there is plainly a tension there. So what's the upshot? Well, this brings courts and Parliament, and indeed courts in the executive, into more direct conflict, and will also inevitably mean more applications to the European Court, and query whether that might mean that the domestic courts are avoided altogether. Because it's clear that a direct declaration of incompatibility isn't an effective remedy for the purposes of Article 35(1) of the European Convention of Human Rights. So one does not have to exhaust that remedy in order to apply directly to the Strasbourg courts, query whether we're just going to get more leapfrogging direct to Strasbourg. On the next slide, I look then at damages. So what are the remedies that are available? Now, it's clear that all remedies that are available currently to the courts, Clause 17 makes this clear, are available in relation to human rights breaches. So there's the declaration of incompatibility, and then there's also any other order that's available to the courts. And indeed, damages can also be awarded. However, there are limitations placed on the award of damages. So first, damages in Clause 18.6 can only be, well, in Clause 18, apologies, can only be awarded, one, if the individual has suffered loss or damage, and two, damages are required in order for that to be a just remedy. So there's a second greater hurdle which doesn't currently apply to the award of damages. Second, damages must keep pace with and must not outstrip the awards that would be given by the European Court, which of course are in and of themselves quite low. And second, there's, well, just to say there's one caveat to all of this in relation to damages, and that's that the jurisprudence which is currently in place on Article 5, i.e. where there's been some kind of unlawful detention, all of that domestic jurisprudence around unlawful detention which has developed in relation to Article 5 remains unaffected by this. So this applies to any convention right other than Article 5. Finally, the new thing that applies to any convention right other than Article 5 is in Clause 18.6, which is that the court must take into account and give great weight to the importance of minimising the impact of any contemplated damages award on the ability of a public authority or any other public authority, so not even the authority that is the defendant, to perform its functions. And Clause 18.7 obliges that to include having regard to the potential impact of future damages awards. So this ties in with the theme that Verity was developing, which is a certain approach to protecting the way in which public authorities operate, including in relation to remedies. And it also, in my view, it ties in with another theme, which is that kind of suggestion of undeserving claimants. There are a number of clauses which we haven't touched on to do right up at the front of the Human Rights Bill, which looks to limit or ameliorate the way in which a number of undeserving claimants can rely on human rights. For example, prisoners, for example, those who are facing deportation. Ranjit's mentioned the permission filter. And in my view, the limitation in relation to damages feeds into that narrative of claimants, even having succeeded in showing that there's been a breach of their human rights, are not yet deserving of particular remedies, including damages. They have to jump yet a further hurdle. So moving on then, Andy, what does this all mean for public law litigation? And let me give a soupçon of what I think this might mean for environmental law. I've just highlighted 2 or 3 different areas. First, you may be aware that one of the key areas where there's been developments in relation to human rights is the impact of air quality on individuals. And in particular, there's been a tie-in with the Article 2 positive rights, so the right to have a death investigated, and the positive rights under Article 8 for bodily autonomy, and also potentially intersecting with discrimination, anti-discrimination protections around the impacts of air quality, in particular, the developments which followed the inquiry or the inquest into the death of Ella Kissy Deborah, who died from asthma caused and exacerbated by the poor air quality where she lived. That's a stream of jurisprudence which I think is looking to be developed and may be affected by the Bill of Rights. Second, and most obviously, general climate change impacts and human rights are an area of significant development at the moment. But that relies in particular on the positive obligations under Article 2 and Article 8, and see the quite famous Urgenda case, which was decided by the Dutch Supreme Court, Court of Repeal and then Supreme Court, finding that the Dutch court failed to comply with its positive obligations by failing to set a sufficiently ambitious target to reduce greenhouse gas emissions. You may be interested to have a look at the recent Friends of the Earth decision, Friends of the Earth, Client Earth and Good Law Project, where the net zero strategy was held not to comply with the domestic obligations under the Climate Change Act. There was also a human rights-based element to that challenge, and 2 things are interesting as a result of that. First, the Good Law Project tried to rely on the Section 3 interpretative obligation to interpret various climate change obligations in a human rights compliant way. The judge wasn't interested in that as an approach and said it didn't apply jurisprudentially in the way that the Good Law Project tried to apply it. But that was very particular to their approach. If there are particular claimants who would come forward with human rights-based challenges, that would fall away. But plainly, the interpretative tools will not be available if Section 3 is done away with. Second, the court in the Friends of the Earth case said, well, Urgenda represents a step beyond the Strasbourg jurisprudence. Strasbourg hasn't said anything about positive obligations and climate change yet, but there are a number of cases currently before the Strasbourg court where it's likely that they will speak, and question where on the range of fossilization we will be in climate and human rights terms if the Bill of Rights bill is brought into force as an act. So question the extent to which climate change positive obligations will apply. And finally, there's quite a lot of emphasis in the environmental arena on developing further rights protections, whether that be a new right to a healthy environment, that's something that the UN has put in place, or whether that be protections in relation to rights-based damages arising from, for example, the potential new crime of ecocide. And it looks like the mood music from the Bill of Rights bill is that we're certainly not looking to develop anything new in the area of human rights. In fact, the difficult second album, as Ranjit put it, is a stepping away from the new rather than towards the new. So Andy, on to your part of the presentation and looking at housing.
Thank you very much, Estelle. I came to the bar 23 years ago. at a time when one of the obvious questions in any pupillage interview was, which is the most important bit of legislation currently going through Parliament or having just been enacted? And the answer that I suspect everyone gave at the time was the Human Rights Act, which was, of course, 98 and came into effect in 2000. And it's had a significant impact on housing, although there is a sense, and certainly when I was preparing this short part of the webinar, there is a sense in which it's difficult to see what the immediate impact of the Bill of Rights bill is or will be for housing law. And the reason I say that is if one looks, as you can see from the slide, at some of the main areas of housing law, such as, for example, possession claims, one knows that there has been already a detailed treatment of, in particular, Article 8 and to a lesser extent, Article 1 of the First Protocol in housing, and not least Pinnock, of course. And that was developed in Corby and Scott and West Kent and Haycraft when it was determined that, unlike Equality Act cases, Article 8 matters could probably be dealt with at the first hearing. And also, following on from Lord Bingham, in Karzai and Lambeth and Kay, was only going to really apply in exceptional cases. And it therefore means that in possession claims, one rarely sees a substantive and detailed argument on convention right terms. And as Ranjit indicated, you're more likely to get an Equality Act question, whether that's the public sector equality duty and or discrimination provisions in the second part. So possession claims at present don't tend to engage to any great extent convention rights in practical terms. Allocation schemes are slightly different, and Zed and Hackney is a case which has recently gone to Strasbourg unsuccessfully. I think it was the LF and UK case, and that was a direct discrimination claim which reached the Supreme Court. And that certainly engaged convention rights in the sense of interpretation. In terms of allocation schemes more generally, there's been a long-standing argument as to whether, in fact, they engage Article 8 at all, because, of course, there is no right to a home, although that may be one of the developments that Strasbourg will come to, but there's a right to respect for a home. And there's been, as I say, a debate going both ways in the judiciary and elsewhere as to whether allocation schemes, which of course don't actually provide for a home necessarily, fall within Article 8. But again, allocation schemes generally, particularly when one talks about discrimination, tend to plead convention right matters, particularly Article 14 allied to Article 8, but generally speaking come under Section 19 of the Equality Act and indirect discrimination. Homelessness, again, one doesn't tend to see a great deal of convention right activity in homelessness these days. Most of the procedures have been assessed as being compatible with the convention rights. I've given the example of Ali in Birmingham, which said that a decision by the local housing authority that it had discharged its duty to secure that accommodation was available for occupation by a homeless applicant was not a determination of that person's civil rights for the purposes of Article 6. And elsewhere in the homelessness landscape, the procedures have been approved as being acceptable and not in breach of the convention. I've also cited Encube and Brighton and Hove Council, although of course that was a case which was in particular relevant during the pandemic and dealing with both those with no recourse to public funds and those who are rough sleeping. But essentially the courts found a way of dealing with it, whether that be through the Home Office in the former or through other legislation in the latter. But of course, there was an argument as to Article 3 that was raised in those matters. And lastly, I have set out some of the cases which have confirmed certain of the housing schemes as being compatible normally with Articles 6, 8 and potentially 14. And you see them there, Poplar, Harker and Donoghue in terms of the Section 21 procedure, although as we know domestically that may be going. McClellan and Bracknell Forest in relation to introductory tenancies, Sheffield and Smart in relation to non-secure tenancies, which of course are the homelessness provisions, and Begum and Tower Hamlets in relation to Section 202 review processes and its compliance with Article 6. that all sounds like the slides and my contribution stops there, but of course it's not fair or right to say that it has no impact. And of course, I've cited at the bottom an excerpt from Inside Housing of last year as to the Grenfell Inquiry, and of course the important role that human rights and the human rights of those impacted upon by that disaster had on both the inquiry and obviously more immediately on the people themselves. But in terms of impact, I suppose the main, as far as I'm concerned, and Ranjit mentioned it earlier, the main impact has recently been, and it's not that recent, interpretation. In other words, we've had the Guidon case, as Ranjit mentioned, about the questions of interpreting the Rent Act 1977 to ensure that it was compliant with the Convention rights, and in particular looking as to succession of somebody who was a homosexual couple compared with somebody who was the surviving spouse of the original tenant. That was a good use of the Convention rights to show that it could have a very positive effect. Less successful, of course, is the other case you see there, which is the Samawi case, which has sought to deal with matters in relation to wider issues of allocation. And that was not so successful. But again, it shows that it's there and there to be available for use, and therefore is worth noting. However, in broad terms, the main impact, it seems to me, on housing law is certainly not going to be immediate. It's certainly not going to suddenly introduce, for example, defences or contributions into judicial review claims. And as Ranjit indicated, it's likely to be of assistance, ironically, to local authorities if positive applications are being sought on the part of the claimant in such judicial review applications. And it's also likely to mean more concentration, as there has been for a number of years, on domestic legislation, in particular, the Equality Act of 2010. So in terms of its immediate impact, I have to say my assessment is that it's not going to have any immediate impact, although of course it's going to have, if one looked at housing in its wider sense, and in particular, for example, looked at it in the asylum or immigration concept, there may well be some Article 3 cases where positive obligations are being sought, where it will have a very real impact for the reasons set out earlier by Estelle and Verity, and the limitations there may be on such arguments. And one can see, in terms of positive obligations, there was a recent judicial review on that matter of MG and Secretary of State for the Home Department, which sets out very clearly the existing provisions and availability and benefits of positive obligations at paragraphs 7 and 8 of Mr. Justice Johnson's judgment in that case. So in terms of impact on housing law, interpretation certainly, positive obligations, particularly through judicial review, potentially, although as I say, in terms of mainstream housing, not so much. But the lagging behind has been mentioned previously by the speakers. If, for example, Strasbourg did extend, for example, Article 8 to allocation schemes or a right to housing. In terms of ameliorating factors, I finish off by saying, well, that's not positive, of course. Is there anything that we can take some comfort from when one's looking at the bill? Well, as I indicated, we can certainly take some comfort from the fact that the Equality Act, certainly in a housing concept, and certainly when one looks at allocation schemes, has with discrimination. One can certainly look at it in terms of possession claims with Ackerman Livingston, where one would recall that Baroness Hale was looking at proportionality in that case as very much a convention approach to proportionality plus. In other words, it was an increased test for the purposes of the Equality Act 2010 and discrimination. So there's certainly existing domestic legislation which should in some respects cover the rights of people, which may also be covered at the moment, for example, by Article 14, allied normally to Article 8. There's also, of course, the fact that a lot of housing law in terms of possession and injunction claims are referenced by concepts of reasonableness and proportionality again, and those will remain. In terms of any issues such as, for example, questions as to the application of mandatory grounds, such as the absolute grounds recently provided for. Again, they have not shown any sense that those are unlawful in any event per se with regard to Article 8 of the Convention. And therefore, there shouldn't be much change there. And also, of course, as has been said throughout this webinar, the bill gives effect to the same set of convention rights. And it's an odd factor that, of course, there may be a difficulty in terms of where one gets justice and relief, but it's still requirement that the convention rights are complied with. And so in those circumstances, I think from a housing point of view, I think it's a wait and see. I know that Tara and Sarah, who are writing a paper on this and who I've nicked a lot of what I've said from, will be coming up with something a bit more detailed. But I say that there's nothing immediate to panic about, regardless of my personal view of the merits of this bill, which is probably fairly obvious. So on that happy note, I will pass to Ranjit.
Thanks very much, Andy. We're just about 1 hour, but I think we have time to answer a couple of questions. I think that Estelle has one on planning to answer, but before that, there's a question asked, big shout out here to Bracknell Forest, and they say, how will the Bill of Rights change the effect of or approach to judgments given when the Human Rights Act was in force? Now, Verity has already spoken about the effect of positive obligations, but what about those decisions which have relied upon Section 3 to arrive at a particular interpretation of the Act? Now, ordinarily, as you know, where an Act is repealed by Section 16 of the Interpretation Act, that repeal doesn't affect the prior operation of the Act or rights accrued under it. But the question about whether prior interpretations under the Human Rights Act are saved under this proposed bill are in fact rather obscure. There is a provision, Clause 40, which provides a regulation making power, enabling the Secretary of State to amend legislation to preserve or restore to any extent the effect of a relevant judgment of the court. And relevant judgment is defined as one that appears to have interpreted legislation in a particular way in reliance on Section 3. And the explanatory notes say that's to ensure legal certainty, particularly where an interpretation has become an established part of the scheme. But this does rather suggest, and in fact the explanatory notes emphasize this, that unless a particular interpretation is saved by the Secretary of State, then the purpose of the bill is to unravel interpretations of acts decided under the Act. But it's not very clear, and it seems to me that will be a fertile area for litigation. That's the answer to my question. Estelle had a look of absolute horror over her face when I mentioned there was a planning case. Was I wrong?
No, not at all. I just, with one eye on the time, shout out to lovely North Norfolk and thank you for the questions. There's one area where it seems obvious to me that there'll be a significant intersection between this and planning, and that's in the area of gypsy and traveller cases, because there's already a significant emphasis in those sorts of cases on the private and family lives of the particular individuals and how that impacts on the way in which planning decision making is taken around them. Query whether the emphasis in the Bill of Rights on kind of stepping back from affording certain claimants particular advantages or the impact on local authority resources will have maybe not a direct impact on how those cases are determined in future, but an indirect impact, so an influence, a chilling influence. I don't think there is any particular direct impact because that's just, it hasn't relied on positive obligations, for example. Although this is a tricky question, and it's going to be an incredibly fruitful area for lawyers to argue the extent to which what was previously easily seen to be a positive element of the exercise of a right actually falls within a negative or refraining understanding of that right as well. It's jurisprudentially and philosophically a very difficult dividing line to draw between what is part of a positive obligation and what is part of the negative requirement on the state to refrain from doing something. So watch that space. And then otherwise, in terms of planning matters, there's going to be that intersection with climate change, and the extent to which there was any impetus behind that drawn from human rights will obviously be affected by the Bill of Rights and whether it comes into force. Of course, just to trespass on people's time, one more moment to say, all of this is very still up in the air. And it's important that we get to grips with what this bill means and what its ramifications could be, but always remembering it is and remains a bill. If it makes its way through Parliament, it may change significantly. And I say if it makes its way through Parliament because we're seeing a significant degree of upheaval in government at the moment. And the extent to which the main proponents of this bill, Dominic Raab and Suella Braverman in particular, will play a role within the executive and or will be focused on other matters is an open question. So this is very much an area where we will have cause to meet again. Thanks very much.
Thank you, Estelle. Just on that last point, and just to trespass a little more on your time, another question we were asked is, was Suella Braverman quite so gung-ho when she was a pupil at Chambers? Little known fact, listeners, she was a pupil at Chambers. Well, Suella wasn't. In fact, she has published articles describing her time here when she was a shy Tory in a bunch of lefty lawyers. That's not quite the set I've been a member of for the last 25 years, but that was her take on it. Anyway, that's in answer to your final question. Thank you very much for listening and watching. I think the slides will be put on the website in the usual way. There's some lovely books there for you to read and enjoy. And until the next time, thank you.
Thank you, everybody. Bye-bye.